think that both of them violate this new amendment in the Ohio Constitution, as Kelly?
I think, I'll admit that what I've looked into mostly is how it affects House Bill 79, and I've been consumed doing that, not so much on 125, although I am aware of the legal theories that go into how this would affect 125. But I think with 79, it's quite clear, because, I know that people who have testified on this bill, and certainly some of the legislators know what the effects of 79 would be. But 79 at its core is really supposed to be about keeping Ohio out of the Affordable Care Act at the federal level. But the way that they're trying to accomplish this is by saying, okay, so we're not going to allow any health plans to offer abortion coverage and still be part of Affordable Care Act as it trickles down to Ohio. As Kelly has pointed out, this is unnecessary legislation. There are already laws at the state and federal level that would prevent this, and so what it really does is it makes it unnecessary. And so what are they trying to do then, if they're truly aware of this, and I believe they are? And I think they're trying to further restrict the ability and the constitutional right of women to choose. And so they go one step further with 79, and they say you will not in Ohio be allowed, the way that the language is written, it's very plain. I mean, the bill is only a handful of lines, and what it says is that these health plans, if they are going to be part of the Affordable Care Act here in Ohio, these health plans, people cannot purchase that insurance even with their own money. So you've got a choice as a healthcare company here in Ohio, basically. You can be part of the coverage that's offered as part of the Affordable Care Act, or you could say, no, I don't want to be a part of that because I want to keep offering abortion coverage to Ohio's women and families. But you can't do both in Ohio if this bill were to be passed into law. And that restricts the ability of women and businesses and families to spend money as they see fit. And I find it ironic with the passage of Issue 3, I think some people, some analysts at least, saw that as here in Ohio, people are sending a clear message that they want government out of the business of healthcare. That's how some people analyzed that particular vote. The ironic thing is then I think some of these same supporters of Issue 3 are turning around and saying, you can't purchase, even with your own money, certain types of health insurance. And I think that a lot of supporters of Issue 3 and a lot of people who weren't supporters of Issue 3 combined will be very surprised that Ohio legislators are trying to go to that length.
Do you think that 125, if you file a lawsuit, it wouldn't be under the state constitution, it would be in a federal?
Those are typically, these lawsuits are filed in federal court. I'm not part of the legal team. I'm not a lawyer who's discussing this. I mean, I'm privy to some of the discussions and stuff, obviously, but the legal theory will develop over time. Again, we don't have, for all we know, these aren't the final versions of these bills. I mean, they could be changed still. There is still that opportunity. So we don't know what the final product exactly is going to look like, and that's when we will really start to develop our legal strategy, is when we see what the final bill will look like. But in the meantime, there are always ongoing discussions about, do you file in state court, do you file in the federal court, do you do it under state claims, federal claims, both. That's something that's being discussed even as we sit here.
But to be clear, the heartbeat bill, you're not saying that the new constitutional Issue 3 that was passed prevents the heartbeat bill from going into effect.
I'm saying what I have focused on has been 79, and I have seen where that could potentially apply to 125. What I'm saying is I sit here now, me individually, 79, I'm quite clear that it applies to that, and I would not be surprised at all, I guess is the way to put it. I would not be surprised at all if the same theory is used in our lawsuit against 125. It's just, again, we don't have the final bill. We don't know what exactly it's going to say, and these are discussions that are still underway as part of our legal team. I can't say today exactly what the complaint and the motion is going to look like.
But on its face, would you think House Bill 125 violated other Supreme Court decisions, or?
Oh, I think 125 is Kelly could certainly speak to this. I mean, I think 125 is, what they're trying to do is get, I don't know, can you legitimately think of a way to get closer to overturning Roe v. Wade than having a law like this?
I think the only thing that comes close is the personhood amendment that another group is trying to put forward. And I think in terms of House Bill 125, my opinion is that it does also violate Issue 3 in the state constitution, because it bans the purchase of health care. Abortions are healthcare. They are medical procedures. They are regulated by the Ohio Department of Health. Doctors are required to be the professionals that perform them. They are healthcare. The state of Ohio cannot prohibit the sale of healthcare under the state constitution anymore.
Well, wouldn't if you were to go forward with challenging, based on issue 3, would that still leave hanging the question of whether the heartbeat bill is in fact a unconstitutional overturning of Roe v. Wade?
That would be left to litigators. That's not our role, but I think it's clear, as having been an advocate for abortion and reproductive rights for 10 years, that this bill is intended to challenge Roe versus Wade. They intend to push back the point in pregnancy at which women can access safe legal abortion, not just in Ohio but across the country. That has clearly been the strategy of the proponents of this legislation. And I think it's now, because of issue 3, also not just in violation of the United States Constitution and Roe versus Wade, but also the state constitution as well.
Yeah, I don't think, when we file our lawsuits, you won't be seeing it. The legal papers will not depend solely on how issue 3 fits into this. There will be other claims that will be brought in that lawsuit. I can say that with great certainty, because any law that affects the ability, the right of a woman to exercise her constitutional rights in this regard. There are many other things. There's a standard reproductive rights case law. There is equal protection law. There is specific language under the Ohio Constitution. I mean, there will be, as happens whenever we file these types of cases, it's very rarely on just one avenue or on one count. We'll be probably, I'd imagine, throwing the whole kitchen sink in there.
Could there be a parallel state and federal court challenges? 125?
There could be. Oftentimes what you find is if different parties file lawsuits challenging the same law, sometimes what will happen is a judge will combine the lawsuits at that point, instead of having them litigated separately, especially if it's in the same court. Like, for instance, if it were to be in the Southern District Court of Ohio, the federal trial court down here. It's not unusual for a judge to just combine the lawsuits at that point, and then you've got all the lawyers and all the defendants involved on one lawsuit. But that said, that doesn't have to happen, but that is I've certainly seen that happen before with ACLU and related lawsuits.
There would be multiple reasons for a challenge in 79 as well as 120.
Sure, absolutely. Same logic applies in that this wouldn't be an issue simply saying issue 3 prevents you from doing this. That would be part of it.
Are you looking at other bills that have passed? Are you looking at any possible lawsuits on those? I think there was like a 20-week viability, or the viability bills that have already been signed into law by the governor?
What I know right now is with our legal team, our board of directors, and our organization, because these are the most timely right now, and I think maybe the most serious when it comes to challenging women's constitutional rights. These are the ones that are on our plate right now, and we're ready to announce that we'll sue. Some of these other ones, what the courts have done is they have been, courts have said, okay, you can't just totally overturn a woman's right to terminate her pregnancy, but you can throw a bunch of roadblocks in the way. And courts over the years, over the decades, have accepted this as long as you whittle away at it, they don't seem to have a problem with it. It just becomes a question of how much can you whittle away before a court starts to say, no, that's too much. So
it becomes an undue burden is what the court calls it.
Yeah, so this has been done kind of piecemeal over the years. And so one of the things we look at with some of these other bills is because they're really just a continuation of what legislatures and the General Assembly have done in the past. We start to have these discussions as to whether has the scale been tipped far enough in one direction that we can expect to both win a lawsuit and whether it makes sense for us to file it in the first place. But I will say, we are very aware of all of these bills here in the General Assembly, and with each of them, we discuss when to offer testimony, how to offer testimony, where along the process to do that, what legislators to visit, all the way on up to saying, okay, if and when will we sue over this, and how exactly we will go about it. So there is a potential, certainly, that we will sue over those other bills, but our analysis of those bills and what those particular issues aren't the same as they are with these two particular bills, which are just so clearly, absolutely. I think you'd find even some federal courts that might not agree with the ACLU on a whole lot of issues that are going to take a look at both of these bills and the law that would be established by them. And I think they're going to be very skeptical as well, to say the least.
So these are two cases where you think that it's been tipped far enough for you guys to get involved?
We announced this morning, even before the laws, reach the final stages and are, signed by the governor, we've announced we're going to sue. So it's, we don't oftentimes do that, I'll say. And so we want to send a clear message by being forceful and saying, look, you pass these into law, you can expect an ACLU lawsuit. So, these are the, as far as, it's Port Kelly, I mean, and Gary and everybody else, a lot of their professional, they haven't had an easy 2011, that's for sure, when it comes to what the legislature has been doing with regards to reproductive rights in women's health. But again, we felt strongly enough about what's happening right now that we wanted to send that very clear message that we will sue.